case, People versus D'Amico Cummings.
Good morning or good afternoon. This is Public Defender Lawrence Perry on behalf of Mr. Cummings. Cummings, please state your name for the record.
Good morning, Your Honor. D'Amico Cummings for the record.
Teresa Claire on behalf of probation. Your Honor, Mr. Cummings is before the court for a violation of probation hearing. Mr. Cummings did have a prior VOP hearing on June 12th. At that date, the court had ordered him to serve 10 days in jail for his violations to date. Mr. Cummings failed to report to the jail as the court ordered him to do that, and the bench warrant was issued. He has been since picked up on the warrant and has been in custody. At this time, Mr. Cummings is still in the same situation he was on June 12th. He still has a balance of $1,255. He's made no payments to the court. He failed to complete the level 2 driver rehab program, failed to complete 100 hours of community service. He has another new pending case since June 12th, an alleged R&O, date of offense, July 22nd, 2024. He does have a PCC on August 1st in that case. So the court is also aware Mr. Cummings does have another pending case on 14B. It is a domestic violence case. He goes for sentencing on that on Monday. That is not a violation of this case. It happened prior to his sentencing. However, he also, in that case, has a bond violation as he violated the no contact order in that case. That will be addressed at their sentencing hearing as well. Mr. Cummings, in this case, Your Honor, it started as a felony case. We did get him sentenced in it. However, prior to all of that, getting him to sentencing in January, he had multiple failure to appears before this court. He continues not to follow court order. Given that he has demonstrated that he does probation is recommending that he serves 365 days in jail, credit for 85 days that he served to date, to serve the balance, that he complete the in-jail MRT program with the court to consider early release upon his completion with that, and that he be discharged from probation without improvement with and waiving remaining terms, accepting his financial obligations.
You know, I did have a lengthy conversation with Mr. Cummings yesterday. He does admit that he messed up on probation.
So he admits to these violations.
Yes, except for the pending cases for obvious reasons. He wants to ask the judge for mercy in this situation. He would like for his probation to be reinstated. He said he is willing to comply with probation and get done what he needs to do. However, he does want to take responsibility for not doing what he needs to do over the past couple months. So when I asked him what's been going on, he kind of gave me a litany of things. He cares for his 5-year-old son, who is going to kindergarten in the fall. He also has a baby on the way. His partner to the 14th, but really the baby can come any day. Those two things, as well as his job, he's working Amazon night shift 40 hours a week, essentially distracted him from taking care of what he needs to do on this probation. He does live with his mother and his partner, as well as his children, so he does have a support system. He says he can make payments. He is working full time, and he does have some savings that he can put a pretty substantial payment toward his fines and costs. He said his mom can come up and pay $1,000 before he even is released from jail. He mentioned to me that he has been successful in other probations, and thinks he can be successful here if the court is willing to give him another chance.
How did he get picked up on this warrant?
The police came to your apartment for an unrelated matter. And Mr. Cummings would like to make a statement. He wrote down
Did you have something, Ms.
Sure,
Polari,
I just
before he?
wanted to say, when the police did arrive at the apartment, it was for an unrelated matter, and I believe that he ran, and that's where the new RNO case came from.
Go ahead.
And I want to start like this and say I do got a 4-year-old about to be 5 in October, about to start school this fall. I got a daughter due any day this month. I was working a night shift at Amazon, 40 hours a week, 10 hours and 30 minutes a day. I was laying down on my side. I didn't look at it as a punishment, but I looked at it as an opportunity to do better and be better and get my life together. I can't have warrants and actually be responsible for my son and get to school every day or even to a bus. Please don't punish me or revoke my probation. I think y'all can actually help me do and be better. I signed up for Michigan Reenters to try to get back in school and see what college is like, even though it seemed like I haven't been trying. That's something me and my probation officer spoke about. I can and I'm willing to do extra classes like MRT free and on probation. I'll pay to start my driving class before I'm even released, if considered. And if you can take thought that I'm on probation for being a victim in a car accident I was in or at fault for, I went to the hospital with bad injuries, just as everybody else. Like, please, Your Honor, I've been getting dealt a bad hand. And I always have just try to be the best I can and resolve every issue the best way possible. Honestly, I'm not the best, but also not the worst. Like, please, Your Honor, I beg you, please, can I have one more chance to show y'all I actually had a bump in the road and I had to get over it, please. If you see me again, you can revoke my probation, give me a year or anything. Like, I really do and truly apologize for the confusion and decisions I left y'all left you, my probation officer, to ponder with. But I really have just been working, trying to be there for my son and the mother of my child that's currently pregnant. Like, please don't punish me yet, but give me one more chance. Like, I'm actually a full-time father and my son stays with me. I can't imagine just leaving my son out the blue like this. He missed me as we speak and think I'm on vacation. I'm going to be a full-time dad to my daughter too, that's due. This is the first time you see me for a reinstatement and the last time if possible. I'd do anything to be there when my daughter is born and put my name on the birth certificate. I watched my son go off and start his first day of school. Your Honor, I plead and please, I'd do anything, even if it was double my community service, double my restitution, and add extra classes. I'd do it and complete it all. If you can, please consider everything I said and give me a chance. It would be the biggest and best blessing. I know I haven't paid yet, but I thought I had time to. I had kids, house, and life things to take care of. I haven't started my driver class because I was supposed to start it a month after being released, but I didn't have a job or was told that I had to pay to start it after being released. I know I haven't started my community service, but I checked in the places that let me serve the community legally to get this out the way. If I can, please have one more chance to show y'all. You wouldn't regret it, I promise. But that's all I have to say and ask of Your Honor, sincerely.
Cummings, here's my problem. On September 13th, you were set, well, before that, I think I took your plea. You were supposed to appear for sentencing. Actually, I didn't take your plea. Looks like it was taken by another judge. But anyway, you were supposed to appear for sentencing. You were supposed to do a PSI with the probation department. This was back in September 2023. And you don't do any of that. And I have to issue a bench warrant. Somehow or another, it looks like that may have gotten set aside in January. And then I adjourn your sentencing January 9th. We had to somehow or another find you from September to January. And then on January 9th of 2024, I adjourned your sentencing. It was adjourned by probation to January 24th, 2024. You show up on January 24th and they give you a sentence. Relatively straightforward sentence. You were in custody at the time. And I laid out everything that you needed to do. That was in January. You really don't do anything on probation that I ordered you to do. So then you show up June 12th of this year on a violation of probation hearing. And At that time, and I think you were on Zoom, you were out. We told you the things that you were supposed to do or hadn't done and try to get corrected. And at that point, I kind of just sent a warning shot to you and told you, you got to do these things. And I ordered you and ordered only 10 days. And Ms. Polaris trying to work with you too. I mean, we didn't order you served the full time. We said, here are the things you haven't done. You need to get them accomplished. So I ordered 10 days in jail, gave you a specific day to report to probation on June 24th, 2024. Did you go?
I was in warrant status. I don't think I could have. Your Honor.
Oh, you could have.
You're right, for sure.
And then ordered you to become compliant with all the previous terms that I ordered. So I gave you another shot from January to that June day. The 10 days, because you were on Zoom, I told you exactly what I would do. I said you're to report by 6 p.m. that day, or I was going to issue a bench warrant without bond. You must have thought I was kidding.
No, Your Honor, not.
Then why didn't you go?
I didn't make it by 6. I knew the deal could have been off the table, but I definitely was not thinking you was joking.
Why did you not turn yourself in then?
And I was
You
trying
want me to give you another chance,
to plead.
and you did nothing.
I could complete this probation. Promise.
What?
I can and will complete this probation, possibly, if possible.
You can't, you do what you want to do.
I'm gonna speak
When did you get picked up on this one?
about 20, if I'm not mistaken.
July 20th. Okay. So between June 12th, when I ordered you to report to the jail, and that day you got picked up, what were you doing to correct this?
I was trying to work, make sure I had some money, so if I had other bonds.
You-
But I do apologize, and I can't say this, Your Honor.
Here's my problem. You're apologizing because you got caught. You were, if those police had not come to your door that day, I still wouldn't be seeing you.
Yeah, I probably would have turned myself in still.
When?
That was all.
In the 45 days from the time that I ordered it to the time that you got picked up, at what point were you going to turn yourself in?
As soon as I had enough funds to take care of other cases that's holding me with no bonds and counties like tickets. And I was trying to be there for the mother of my child that's currently pregnant. I would have done my probation this whole time, but I had other warrants stopping me from doing my probation. I'm not going to say, yeah, I didn't. I'm not going to say I didn't turn myself in. It was other warrants, other cases that's stopping me from being best at what I can show y'all and doing my probation.
I've given you an opportunity to show me. I'm coming up on a year, and guess what? What have you done? Nothing. Nothing. And then you're gonna, and
I
I
tried.
try to give you at least a gentle nudge, and you still don't do anything. Nothing. You tell me one thing on this sentence that I gave you that you've done.
It was my first time.
Tell me one thing you did.
I checked in. It was hard. I mean, I did check in, do the non-report.
Why is it that you just can't say, Judge, I did nothing?
I did nothing.
Because I'm looking right at it. You did nothing.
You're right, Your Honor. You right.
Everything with you is an excuse.
No excuses as a man. That's what I was taught. so I don't try to make excuses, honestly.
You've made excuses since the time you first started talking. Everything that's come out of your mouth is an excuse. I sit here and I give you a chance to do it. We wait 6 months, correct something. Anybody that is on probation in my court, if, you know, and I feel bad sometimes for Miss Polera, but she doesn't mind doing it. If you're having problems, you'll walk in, you talk to her. But you wouldn't even do that. You thought this was a game. You thought when you looked me in the face on Zoom and I told you when to report that I was just kidding. Nothing that comes out of my mouth am I kidding. I told you to report. I told you when to be there. And I told you how long you'd be there. And I told you what I would do if you didn't report. And so you know there's a bench warrant out for you. Because at least you took me for real on that I was going to issue a bench warrant. So when the police show up, what do? You don't even say at that point, I got to deal with this. You take off running, allegedly, I guess we'll say at this point. And where was that going to get you? Got you right here. And after all that, Mr. Cummings, you want me to believe anything that's coming out of your mouth that doesn't resemble an excuse.
I don't got no reason to be trying to have warrant statuses, and
You have no reason for any of this. Everything that has happened that's bad in this case is no one's fault but yours. And the problem is, had you gotten to your attorneys, had you gone through and you were truly going through doing something, hey, they would have helped you out. There's no doubt, Ms. Perrin or Ms. Pate, they would have been all over my coordinator's email, trying to figure out something to do. Quite frankly, even if you had at that point gotten to Ms. Polera, she would have been trying to do something.
I didn't want to be disrespectful. Not
Oh, too late. You disrespected everybody here. So don't even play that game with me that you don't want to be disrespectful. You intentionally were disrespectful. You intentionally thwarted my order. You intentionally then tried to hide and seclude yourself. You were disrespectful allegedly to the police when they showed up, told you you had a warrant, you take off. Every move you made has been just coated with disrespect to everybody involved in the process.
I wasn't trying to be disrespectful, calling my probation officer and not coming in to take care of the business. And I didn't even talk to the police or anything. They didn't tell me anything.
Okay. You had a warrant, you knew it, you took off. And if I didn't have those two gentlemen behind you right now, you'd run off again.
Definitely.
Every time. Yes, that's what you do.
I can't run. Yo.
What?
I can't run. Yo.
You can't run?
I can't run. Never.
I know, because you kept running before. And that's why you're here right now. That's all that you've been doing. Doing nothing and running.
I haven't had the probation because I had warrants for other cases. I would be straight on track with probation to this day. It wasn't for the other warrants, Your Honor. I promise you.
So you're telling me you weren't doing probation because you had warrants? Yeah, why'd you have warrants?
That's the reason
Why'd you have warrants?
I had bond
Because you
violations.
hadn't done what you were supposed to do before.
They wanted me to turn my all type of. Your Honor, if I didn't have other warrants, I'd be straight on track with probation. If I would, Miss Polaire is a good lady. I know you don't try to be as hard as you do or want to be, but
Oh, I don't. Mr. Cummings, I do not want to send you to
y'all
jail.
are not
I,
nobody.
Mr. Cummings, I do not want to send you to jail. I do not like sending people to jail. I try to bend over backwards to give people the opportunity. When you need a nudge, and I may have to do a little bit of time, I do a little bit of time, trying to at least get your attention, get you back on track. All of those things, every one of them. I've tried with you. And you done nothing. I don't even have anything in this sentence I gave you the beginning of this year. I have nothing that I could point to say you did or tried to do something. I have nothing.
That's what's off paper.
I have nothing.
Get it. I'm Your Honor. If it was
You could have, no, you, Mr. Cummings, understand this. Your promises are no good to me.
I know
Your
that-
promises are no good.
Can I say one thing? I wouldn't have this warrant for probation if I didn't have the other warrants. That's how my probation. And I wasn't communicating with y'all or doing what I was supposed to do or should have been. But that's not me though. I've for sure completed a probation before I could do and complete this.
You
case.
still got warrants.
Everything, this is what I had to take care of. If it ain't a ticket, this is the only things I had to take care of.
Your Honor, I think he's referencing the domestic violence case, that he did have a warrant for. But
He still does have a warrant out of 35th.
and he does have that drug license.
You don't take care of business. I can't help you. I really can't. Anybody that walks through that door that tells me they want to do something, want to follow what we say and try to work hard to try to change things, I'll help them. I know there's no two ways about it. And my entire staff, my probation staff, my staff will help you do what you need to do. And I know your attorneys. If you had reached out to them, they would have helped you. You just didn't. You wanted to do it your way. And your way doesn't work. So now we're going to do it my way. And it's just going to be harsh.
Chance to show y'all I will take care of this. I promise you not see me again. If it ain't to be getting released off of probation early or anything.
I'm going to waive the remaining terms, accept the defendant's financial obligations. I'm going to discharge from probation without improvement. I'm going to order 365 days Washington County Jail. Credit for the 85 days that you served. Defendant will serve the balance. I will consider early release upon the completion of the MRT jail in jail program. I will consider release. I don't know whether I will release you, but that's going to be the first step you're going to have to do. You don't want to do it. You got 290 days to figure it out. I'm done.
Looks like court's decision. What I have in the file here as I call 23 CR 122. You were Courtney DeRista Shallow, present with your attorney. And Mr. Dusler, there is a motion to revoke unadjudicated probation. I see that was most recently filed. And maybe there's another one. I don't have that. But I have this one filed on May 21st, 2024. And is,
It was an administrative hearing requesting a first amended, and
let me
that has
just
not been
say,
accomplished
I
yet.
have that in the file. Hold on. Wait, I see something June 25th.
That's it.
That I signed on July 8th.
That's it, Judge.
It
Yeah.
hadn't, I guess, probably worked its way through yet. Well, let's see what it says here. Committed the offense of prostitution. All right.
I mean, we can
I think we
proceed.
can move
Yes,
forward
sir.
without that, with what we have here. And that could be brought in, though, if we have issues concerning what punishment should be. Other crimes, other offenses, bad acts are all part of the equation in determining punishment. It goes to the character of the person. All right, in this motion to revoke unadjudicated probation, does the defendant waive a formal reading of this? And can we proceed in summary?
Yes, sir.
Michelle, raise your right hand. Do you solemnly swear or affirm any statements that you may make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion to revoke unadjudicated probation alleges that on December 4th last year, 2023, you were placed on 10 years deferred or unadjudicated probation for the second-degree felony of robbery. Is that true?
Yes, sir.
Allegation number one states you failed to report to the Jefferson County Probation Office for January 25th, February 12th, March 13th, March 26th, all of 2024 in violation of your requirements under your deferred adjudication order for reporting to the probation office. Is that true or untrue?
Yes, sir.
Did she ever report?
She reported once.
What date was that?
It was in between the day she was granted probation and January 25th. I believe it was January 2nd.
Was that the very first time? Okay, so she reported the first time and then that was it. And then absconded, as it were, disappeared, lost us, no longer on the radar. Number two, you failed to provide verification of performing community service hours as required. I presume you probably didn't perform any. Is that true? Is that true? Is that true or not untrue? We'll talk about explanations here in a minute. Is it true? Okay. And then finally, you failed to pay court assessed fees. I'm going to skip that one. Okay. Are you pleading true to allegations 1 and 2 here voluntarily and because those allegations are true? Do you understand? By a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant the motion to revoke probation. Your probation can be revoked. You can now be found guilty.
Yes, sir.
And then sentenced up to the full range of punishment, which is no less than 2 nor more than 20 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true to allegations 1 and 2 of this motion to revoke probation. All right, State of Texas. Did you want to supplement anything with the probation officer?
No, Judge,
So
I don't have any offense reports and I
Well, no, I'm talking about just what she's pleaded true to. I'd like a little more about.
sure. Can you state your name for the record, please?
Raise your right hand. Do you solemnly swear or affirm the testimony you are about to give us truth, whole truth, and nothing but the truth? So help you God. Go ahead. Yes.
So
It is true. I interrupted you before you could say true. Yes, or yes, you were accepting the oath, correct?
So are you the probation officer for Courtney Shell, or are you filling in for someone else? Currently the probation for. How many times have you seen Ms. Shello?
I have seen her
And when was that?
January 2nd, 2024.
And was she ordered to report to you since that time?
Yes, she was provided with a next report date.
And what type of efforts have we made to contact her and try to get a hold of her?
Tried to call her. We've looked to see if she was in custody, sent letters in the mail.
So all the usual things to her last known address and phone numbers. Have you had any luck talking to her? So was she supposed to perform community service during all this?
Yes.
And has she performed any hours of community service? Has she paid anything on this fees? Has she tried to contact your office that you know of to try to reschedule any of the appointments she's missed? And has she also just recently been arrested on an offense of prostitution? And is that how she came into custody so that we can have this hearing? It's not like she turned herself in or anything, right? So all of this time that she was supposed to do, and she hasn't really done anything on this probation except report that one time. Is that correct? I pass witness, Judge.
No question.
Short sometimes.
Okay, anything else from the state?
No, you're.
Defense?
Yes, Ms. Shaw, I talked to you concerning the motion to revoke probation, and the fact that you failed to report. And you understand that you're supposed to be reporting on a regular basis. But you told me that you quit reporting because you had to stay with your sick mother, is that correct? And did you try to notify the probation office? Did you call up there to try to talk to someone? Okay, but you never actually physically talked to anybody? Did you talk to this lady who's your probation officer? And what did you tell her?
I told her my mom was sick and can we reschedule? She rescheduled. My mom was in a hospital. I couldn't make it because my sister had to work and my niece was out of town working. Doing okay. And
When was she placed in jail, please? Thank you. Go ahead.
Go ahead.
and she just kept on like, I'm sending payments to the phone. We got text messages where she sent messages telling me to report. And I got messages where I was calling to leave messages on her phone.
You do understand that you're required to report probation on a regular basis, correct? And even though you had some family issues, you still should have been reporting.
Correct.
You know, so you recognize that if the court were to allow you to stay on probation, that you would be required to report on a regular basis in person. Just if you ordered to do so. Are you asking the court to give you another chance to let you stay on probation rather than revoke you and send you to prison this time?
Yes, sir.
Anything else you want to tell the judge?
And for the community service, at that time she was giving me community service. She said there were no officers to do the community service.
You've only spoken to her one time,
No,
correct?
I've seen her more than once,
How many times?
approximately about 3.
Okay. Is that true? Did you want to ask her some more questions to follow up based upon what the defendant's testimony is?
Not sure, but I'd like to ask the defendant a question.
Well, I'd like to know, she's saying one time that she talked to you.
Well, I've already asked her all that about whether or not she got any phone calls, anything from the defendant. And she said, no, she hadn't received anything.
I've talked to her. And it's on my mother's phone where we talked.
You've been on probation now for going on 7 months.
Yes.
How many times did you report?
3 times because my mom was sick and I was the only one there.
You reported 3 times. You heard the lady's testimony that you were only reporting 1 time. Did you hear that?
I heard that.
So that's wrong.
Yes.
Okay, all right. Which times, what are the dates that you reported? Because they document
Like the
every
last
time.
I reported.
Well, may I finish, please? What goes on in here is the rudest kind of behavior. People interrupt because you want to bully everybody. You want to overwhelm everyone. You want to be the one doing the talking and nobody else. It's your way or the highway. Nobody else matters. That's the impression I get. Be quiet for a minute and then you get a fair opportunity to speak. That's the way we learned when we were kindergarten. Right? Yes. Okay. She says, according to this, the probation officer, and according to the evidence, you only reported one time, and that was that first time, which was 6 months ago, I guess, and which would have been in December,
She recorded on January 2nd.
January 2nd, the day after. Okay. And here we are, July. Getting, we're in the middle to end of July, which would be going on 7 months. And according to the probation office, we only reported that one time. And they document every time people show up. But it's your contention under oath that you went to the probation office 3 times and checked in and 3 times. Can you, is that right?
I called.
Is that right? Oh, you called. You
I
didn't
went
show up
once
in
and I
person.
called twice.
Can I? Let me ask a question, then you can answer. I'm gonna tell you that one more time. That's real simple. Did you show up in person 3 times? Yes or no? Is that, speak out so she can
No.
take it in? No. Right. So you showed up in person 1 time. Would that be fair?
Yes,
The other times you say you called.
yes.
All right. It's been 7 months, 7 months, and you only showed up 1 time, correct?
Correct.
All right. Do you see anything wrong with that? Because you're supposed to be showing up regularly like everybody else does. Everybody else does weekly or monthly. It depends on what the probation office determines. But everybody else who's on probation has to, 5,000 people have to show up regularly. Why do you think you are different? Go ahead.
I don't think I was different. I was just like, my mom took sick.
For 7 straight months?
She hadn't already put a warrant out. Like in March or something.
That's not the answer. For 7 or 8 months, yes or no? You couldn't have reported any other time? Or could you?
I could.
But you just decided you're gonna do it your way.
Why go and she put a warrant?
So then you're saying your goal then is to evade the warrant and not be brought into custody? You're looking up like this is boring you. Are you
No,
bored?
sir. I'm just
All right.
looking up because
All right. I'm looking at the post-sentence report on this. And it shows the circumstances of this case, which are serious. And the lengthy set of misdemeanor convictions that you had. Okay, so you're over at the store on College Street, the Mercado de Familia. You know what that stands for in Spanish?
Mercado, grocery store.
De Familia,
No.
the family store.
Oh, okay.
And you are, the authorities there, the people who run the store and operate it, confront you on aisle 5 following something suspicious. They followed you. Well, they said they observed you loading items from a handbasket into your oversized purse. So you refused to talk to them, they say. They followed you into the parking lot. A physical altercation ensued, resulting in injuries to 2 people who were people at the store trying to protect their property. One person was struck in the face by you with a closed fist. Another person was struck in the right cheek by you with a closed fist. All trying to retrieve their stolen goods that you had placed in that purse. So let's see. The store manager comes along, manages to get the purse with the stolen items, and then allowed you to leave. And then they filed charges. And because of the violence involved and the striking of 2 or more people, you're charged with a robbery. And yeah. Okay, so we placed you on probation, and you knew when we put you on probation, you were completely made aware that you were looking up to 20 years in prison if you failed on probation. And here 7 months have gone by and you appeared one time, and after that you have elected to disregard the rules and not comply with probation and do it your way. And here we are. What's the state asking for?
Judge, I believe she has a revocation where she got 3 years last time. I think.
I don't know that. I'm looking at this post-sentence report. 3 years for what?
I think there's a felony on the last page. Next page over, right up to the top up there.
It says probation revoked, adjudicated 3 years in prison. What court was that in? This one or 252nd? Can you pull that up, please? A prior conviction? It looks like 2019.
Drug court. But right now,
Maybe.
I think it was when we were covering drug court. Tampering and manufacturing,
Tampering was dismissed.
okay, then the manufacturing, they were together, it has you, but it also has DC3, so but I think it was us.
Okay, so according to this post-sentence report, the defendant has a prior conviction. That is a conviction before she commits this act. And also, it shows 27 Class C misdemeanors, 8 of which include disorderly conduct, fighting, and failing to appear. Okay.
So because of that revocation and because of the circumstances of not reporting, doing anything, state's asking for 5 years prison time.
She's asking the court to let her continue on probation.
Anything you want to say? No? All right, if nothing further, I'm going to find there is sufficient evidence supporting this motion to revoke probation, if granted by preponderance of the evidence or greater, as allegations 1 and 2 have been proven true by preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty to the 2nd-degree felony robbery voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that hearing to find you guilty beyond a reasonable doubt. Now that your probation is revoked, I hereby find you guilty beyond a reasonable doubt of this underlying robbery in this 23C0122. I find you guilty beyond a reasonable doubt, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. You can't treat people like that, and also you can't absolutely refuse to follow the rules of the law when you were placed on probation. Anything else? That is all.
This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Holly A. Reynolds. It is case number 2021 CR 137. Jill Gillette appears as Greenwood County Attorney, Richard Paw as Defense Counsel. Holly Reynolds now appears about 15 minutes late. Ms. Reynolds, this proceeding was scheduled to begin at 1:00 p.m. today. You weren't here until 15 minutes later. Why is that?
The road construction had a pilot car and we had to wait for the pilot car. Like got 10 minutes outside of town. Last time they didn't have a pilot car when they had the road construction. So we weren't prepared.
We have all participants on the meeting now. We will proceed further. This is scheduled further hearing on a warrant to show cause matter. Court believes that the current allegation before the court is failing to report to her officer as directed. Is that a fair summary, Mr. Ketley?
Yes, Your Honor.
All right. I may address you further later regarding it. I also will note for the record that there was some research done regarding the issue of continuing jurisdiction of this court over this matter. The court does note that at a previous hearing in this case, where the probation in this case was reviewed, I believe that was the hearing of November 18 of 2022, the court reinstated probation and extended it for 1 year, 12 months from the original expiration date. I think the original expiration date would have been January 27 of 2023, which means that the 12-month extension went to January 27 of 2024. The warrant to show cause that's before us today was actually filed even before the expiration date on this case. So it's the court's ruling that it has jurisdiction to proceed further. Mr. Paw, what are your client's intentions regarding the failing to report to her officer allegation?
Judge, which warrant to show cause? The only warrant to show, I see it now, Judge. Never mind. That was done on January 11th, but it wasn't filed until the 10th of April, Your Honor.
You mean the service return on it wasn't filed until the 10th of April?
No, she was arrested on 4/7, Judge. Okay, looks like everything is. No, that is correct, Your Honor.
All right, the court will proceed further then. And again, your client's intentions?
Judge, when I spoke to her last time before we had this issue, her intentions were at that time was to waive her evidentiary hearing and admit to 2 violations as outlined in the motion to revoke probation on 4/23 of 24.
All right. Ms. Reynolds, you've been present when your attorney made an announcement on your behalf that you would now intend to waive any formal due process hearing that you'd otherwise be entitled to, and instead stipulate and agree that you committed the failing to report violation, which was alleged by Mr. Ketley in his most recent warrant to show cause. In waiving your hearing, you'd be waiving the right to require the state to present evidence and prove the allegation by a preponderance of the evidence. You could challenge the state's evidence with the assistance of your lawyer, Mr. Paul, present your own evidence, and confront the state's witnesses unless good cause was shown. Among other lesser remedies that the court has, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Ms. Reynolds, do you understand these things?
Yes, Your Honor.
Is it your intention to waive a hearing in this case and stipulate and agree that you committed the failing to report violation as alleged?
Yes, Your Honor.
All right. The court finds that the defendant has knowingly waived her right to a hearing in this case and stipulates and agrees that she committed the failing to report violation as alleged by Mr. Ketley. I'll obviously ask for recommendations from counsel, but I want to start off with Mr. Ketley. Mr. Ketley, your allegation was made some time ago. What has been the track record of performance of your client since you filed this warrant to show cause in January?
I don't believe haven't had any contact with her, Your Honor. Since I think the last time she reported me on October 18th, and I set her up for November 1st, and then I haven't heard anything since then.
All right. Thank you, Mr. Ketley. Ms. Gillette, based on what's currently before the court, What are the state's recommendations regarding an appropriate disposition here?
Judge, in this matter, we had a previous violation hearing. She was to have a 60-day sentence or sanction. There was a compassionate release for her due to her father passing away, allowing her to go to the funeral, which is not usually a thing that always happens. Sometimes we just say you're in trouble, it's too bad. You don't get to go to a funeral, but in this case, we allowed that for her. She was to have 60 days done as a sanction last time. Promises to do what she needed to do, promises to go to treatment. And here we are with her basically absconded. So with her absconsion from supervision, she just took off. And with her taking off November 1st, 2023, she didn't report and hasn't reported since. Normally, when someone's in trouble, they get right back in and talk to their officer and get into treatment. But instead, Ms. Reynolds has not done that. So my recommendations have to be an outright revocation based on her being an absconder and refusing to comply with anything with her ISO. She still had a balance due at the time that we filed the motion to revoke probation.
What is that current balance?
It was $858 at that time.
All right, thank you. Mr. Paul, as defense counsel, what is your recommendation regarding an appropriate disposition here?
Judge, I would ask that the court sanction her and then reinstate her. I know she's been working in Newton. I know that she's been working hard on her sobriety. I believe she would tell the court that, you know, as evidence today, she didn't have a ride. She lives in Newton, Kansas. Judge, I also don't believe that there's been any other criminal matters against Miss Reynolds during this whole time, which is something we rarely see in these cases. Usually when people are not reporting, they're out doing bad things. And from what Miss Reynolds tells me, she's been out doing good things, trying to better herself, work a job, you know, keep that job. And so that's why my recommendation, Your Honor, is to sanction her with what you feel is appropriate and reinstate her.
Very well. Holly Reynolds? At this time, I would address you personally, and I'll ask you, do you have any personal statements that you wish to make to the court in mitigation of punishment here, or anything further that you personally would like to present to the court in addition to what Mr. Paul has already presented on your behalf?
I'm sorry for being absconded. I didn't become absconded just for no reason. It was just, I had a mental breakdown because my dad died. The guy I was with for 10 years died from kidney failure. It was just so many deaths, one right after the other, that I couldn't handle it anymore. And I mentally broke down and I quit seeing everybody. I quit going to corrections. I quit going to work. I quit doing everything and got really depressed. It's been really hard on me. I mean, there was 5 deaths all within a year. I mean, it was really bad. And I'm still trying to deal with it, and it's hard.
Okay, anything else? Okay, I saw the shake of your head no, so I will perceive that you've completed your statement to the court. Ms. Reynolds, you were placed in this case on reporting probation with a heavy emphasis on the word reporting. ISOs often are very aware of community resources that their clients can be referred to when they're having stressful situations. I'm not making light of the pain that's associated with any of the deaths that you referred to in your statement. Everyone has to deal with the tragedy of death at some point in their lives. When you've had a history of any type of drug offenses, it's really important that you stay in contact with your supervising officer, let him know what's going on with you, and then let him make the appropriate referrals or to try to get you some sort of assistance with whatever problems that you're having. What you cannot do is just check out and use that as an excuse to stop your program. What you do in that instance, Ms. Reynolds, is essentially say, I am not a candidate for the reporting probation that the judge wanted me to complete. Rather, what you're essentially doing is saying, I will just face the music of doing my time. That apparently is where we are in this case, Ms. Reynolds. You've had ample opportunity to correct your behaviors, report to your officer, seek his help, if necessary, demand his help, and to utilize the resources that are out in the community to keep you in the community. You've elected not to do that. On top of that, Ms. Reynolds, you're habitually late for court, including being 15 minutes late today. And indeed, there may have been some road construction and a pilot car situation, but you should have left earlier. You should allow extra time. I just don't think you take court seriously, Ms. Reynolds, much less supervision or probation or anything else that was involved in your case. So the only viable alternative is what the prosecutor recommends in this case, and that is an outright revocation of your probation, and that will be the order of the court. The court finds that this defendant has been willfully non-compliant with the terms and conditions of her probation, that it's not in her best interest to be on a probation, which she clearly is not amenable to successfully finish. Holly Reynolds will make promises and not follow through on them. And she's been given ample opportunity and even been punished for previous non-compliance and doesn't even take serious jail sanctions seriously enough to conform her behavior to what's expected by the court. Therefore, the court does order Holly Reynolds to serve the remaining balance of her sentence in Department of Corrections custody. The court orders her to be taken into custody by the representatives of the Greenwood County Sheriff's Office until her custody can be transferred to serve the remaining balance of the 20-month prison sentence that was originally ordered in the case. With that said, Ms. Gillette, I would ask your office to do appropriate research and determine the appropriate number of jail time credit days to which this defendant is entitled and include that in the journal entry of revocation, which will stem from today. I do know she has some jail time credit. I will note that she does have a 12-month post-release supervision period, which this court re-announces. And I believe that she was in a 20% good time credit category with this particular offense of possession of methamphetamine, a level 5 drug felony. All right, with that order made, Ms. Gillette, is there anything further that you need clarification on?
No, I was looking up her jail time credit. And I don't know if she's got new charges out of Saline County, but she did spend an overnight in there in June, so.
All right. I will say that whatever balance exists in this case is declared to be immediately due and payable and collectible. It can be referred to collection agency for further handling.
What if I can pay it?
No additional fees will be imposed today. It does appear that her balance previously was $858, but the court will not add any more bids amounts, despite Mr. Paz's involvement on her behalf and representation. Court finding that I don't think she's got the financial resources while locked up to pay additional amounts. All right, Mr. Paz, are you aware of anything further we need to address today?
No, Your Honor.
Thank you very much for your timely appearance here today, Mr. Paz.
Hold on. Can they give you?
Yeah, can I get a week to prepare for this?
She is my
This is
employee.
27 months of my life that's gonna be locked up. I need to say bye to my kids. And
I'm
my
not
job.
understanding a thing you're saying, ma'am.
Can I get at least a week to be able to say goodbye to my kids and my family?
No, absolutely not. Absolutely not.
My employee, sir. And she spent the last 2 months getting her life together, at least for that much, to come and work for me.
This court disagrees. Getting her life together would have included reporting to her officer. And she didn't even make the effort to do that one time, according to Mr. Ketley. So I'm not sure what your involvement is here, sir, but the court's order stands. She's in custody of the sheriff's office until she can be transferred to the Secretary of Corrections in their custody.
Get my affairs together, like at
No.
least 20.
No, I'm not going to defer. your time. You need to go into custody today, Ms. Reynolds.
Sir, can you leave, please? Can I give her a hug? Can you leave, please?
That's up to the officer.
Not gonna be
regarding
cussing
good
in court.
advice.
You're not gonna be cussing in court.
Sorry, sir.
Jill, did you have something else you needed to bring to the attention of the court?
No, Judge, I was just filling out all of the notes that I have to for the journal entry. I've
Right.
started.
Thank you to the officer on scene of being able to take her into custody at this time. If
Welcome,
there's
Your Honor.
nothing further then, excuse me? Sorry, did I hear someone?
I was talking to her. I'm sorry, Your Honor. I apologize.
Okay, again, thank you.
NTRP?
Yes, Your Honor, it's 4 piece.
Is there any plea, there's no plea agreements?
No, Your Honor.
All right. 4 cases are called, 22-39761, theft. These are all cases. You're Sinjin Trent Millard or Millard?
Yes, sir, Millard.
Okay. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Okay. There are 4 motions to revoke probation and one in each of 22-39761, 23-680, 23-681, 23-682. Does the defendant waive formal readings of these motions? Can we proceed in summary?
Yes, Your
There is no agreement here, correct?
Honor. Right.
In 22-39761, Mr. Millard, and he waives formal readings of each of these. We're going to do it summarization. In this case, a motion to revoke probation was filed on February 16th of this year. It alleges in summary that on August 7th of last year, 2023, you were sentenced to 2 years in the state jail, probated for 5 years for theft of material aluminum metals. Do you understand what this alleges, and is that true?
Yes, sir.
Allegation 1 states you failed to report to the Jefferson County Probation Office on October 24th, 2023, and for the months of November and December of 2023 in violation of your probation order. Is that true?
Yes, sir.
2, you failed to report to the Jefferson County Probation Office on December 19th, 2023 for an administrative hearing. Is that true?
Yes.
3, you failed to provide verification of performing community service hours as required. Is that true?
Yes, sir.
Are you pleading true to allegations 1, 2, and 3 of this motion to revoke probation voluntarily and because those are true as they are alleged?
Yes, sir.
You understand by a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant motions to revoke probation. Your probations can be revoked and you can be sentenced to no less than 180 days up to 2 years in this state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. We go to 23 CR 680. In summary, this alleges that on August 7th, 2023, in this court, you were sentenced to 2 years in the state jail, probated for 5 years for burglary of a building. Is that true?
Yes, sir.
The same allegations, 1, failing to report, 2, failing to report, and 3, failing to provide verification of performing community service hours. The same exact allegations as the previous case. Do I need to review those with you? And how do you plead to those? Are you pleading true voluntarily and because those are true as they are alleged?
Yes, sir.
You understand? One or more pleas of true, voluntarily and knowingly made, that is enough to grant motions to revoke probation. In this case, your probation can be revoked. You can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true? I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. And I'm going to be repeating this next case as a burglary of a building in 23 CR 681, and the final case, 23 CR 682, is a motion to revoke probation for theft of property. Each of those allege that you, on August 7th, 2023, in this court, you were placed on found guilty, sentenced to 2 years in the state jail, probated for 5 years for those offenses, similar to the other two you've already pleaded true to. Is all of that true?
Yes, sir.
And the same allegations, 1, 2, and 3, in each of these motions were alleged failing to report in 1 and 2 to the probation office for those months that we've alleged and gone over with you that you pleaded true to in the previous 2 cases, and failing to provide verification and performing community service hours. Do you understand what you're charged with in each of these?
Yes, sir.
And are those allegations true and correct in 1, 2, and 3 in these motions to revoke probation?
Yes, sir.
Are you pleading true voluntarily and because those are true as they are alleged?
Yes, sir.
And again, I'm going to kind of be repetitive. Your probation can be revoked for a knowing and voluntary plea of true to 1 or more violations of probation. Knowing that, do you insist on pleading true today to each of these motions to revoke probation, allegations 1, 2, and 3?
Yes, sir.
I find you were pleading true in each of these cases to violations 1, 2, and 3 in the motions to revoke probation, voluntarily, knowingly, intelligently, and because those are true. All right. Now, what shall happen? What do you say?
Judge, just to put it to the court, and that's why there was no agreement. There's still large amounts of restitution in each one of these cases. There's approximately, I believe, $8,683.09 and 22,39761. There's over 17,000 and 23 DCCR 0680. There's 2,000 and 0681, and then $2,633.34 and 0682. There's also a new burglary case that has not been filed yet, but received burglary building kit.
Well, I know what he hadn't paid. What has he paid?
He has not, excuse me, he has not paid anything.
Not one thing. Well, what should we do?
Well, Your Honor, my suggestion would be to now that he's got his plea for true, hold off on any sentencing, release him back on probation, and let's check in like 3 months to see if he's making payments and doing what he's supposed to do. If he is, then let's just keep him on probation or keep him, do the check where we do before. We keep him, bring him back, make sure they're doing what they're supposed to do. And if he doesn't make payments or disappears, then you know you've already got a plea of true at that point. And then put him on some high caseload or whatever the probation department wants to do.
And I guess the state, Your Honor, would argue for that defendant be revoked in 2 of the cases and just add that restitution to the 2 remaining cases and have him sentenced to state jail on the 2 of the offenses, and then remain on probation on the other 2 offenses when he's.
Problem with that, Your Honor, is that means it's going to be longer for him to be able to get the restitution paid. It's also going to make it harder for him to get a job once he has a conviction. So this is regular probation.
What's ironic about it is I'm not really in control, nor are y'all. He is. And that's the tail wagging the dog.
And that's
in
why
this situation, which I don't like.
And that's why I suggested the 3 months to come back.
He made promises. He made promises that he dishonored. He's harmed people. He hadn't paid. He doesn't care. He's continuing to do wrongful acts. He's not reporting properly. He's not paying properly. And now the grand jury finds that he's committed a new burglary.
Well, I don't
he's in control of us. Now we're going to use his word that now I'm going to do the right thing. He hadn't cared. You hurt people. You victimized people. You don't care. You don't care.
You know, I think the only thing I would correct is the grand jury has not indicted him on a new case.
I thought you said
That's we have received it, Your Honor. It hasn't been indicted yet. We just it was just
misunderstood.
It was very recent. It was from June the 24th. Is the offense alleged offense date?
Oh, okay.
So,
All right. Well, then you're presumed innocent.
Right. Exactly. The grand jury hasn't even looked at it, Your Honor.
Taking all that back, it still doesn't matter. He's still in the same position. He made promises he hadn't kept. Promises under oath that he hadn't kept. I mean, not one bit. So why would things change now?
I think he has a better understanding, and if you'd like to talk to him, he can explain kind of why he disappeared for a while, Your Honor, and didn't do what he was supposed to do, and he admits that the reason he pled true to it, he hasn't tried to avoid that. Because I believe he was right
How long have
after.
you been in jail?
Sorry,
How long have you been in jail?
this time, since May 15th.
So he has the ability now, Your Honor, to, once he gets out, he can get to work, start making.
How much time does he have credited? Not much for me to play with. He's got credit for 173. I can only sentence him 180. I mean, he's in control. He's got the leverage, not me. That's not supposed to be the way it works. And meanwhile, people are harmed and
they need to get paid back.
And between you don't seem to really care about others and the flat failure to do anything while on probation, literally anything. I'm supposed to give you another chance because you're so well-meaning. No.
All right, I would suggest.
I only wonder, can I stack these? Which is what I'm inclined to do. Stack them all. You got 4, that'd be 8 years, right? Then he'd have to pretty much do the 8 years. And this is the perfect case for that. The circumstances fit this more about as much as anything I've seen in 17 years. Well,
Except Your Honor.
and I think the people would be dancing in the streets
The problem is
in
there's-
glorious celebration of justice and being done in this case, because that is more than fair.
At that point, Your Honor, the restitution will still be owed. You might take a judgment against them, but
Mhm.
you're not gonna get the money back. And that's the problem versus.
It's just as much owed as it was when he made a promise to pay last year. So there's nothing there. It's, he hadn't cared. And from probation, I hadn't even, I mean, your input is what?
Excuse me, Judge, he only reported one time and that was it.
Since since August of last year?
Yes, sir. He reported on September
Going on a
6th,
year.
23, and that was it.
That was it.
Yes.
Anything you want to say? You have a chance to be heard.
Well, I got a electrician job whenever I get out working with my dad, making decent money. And whenever I got out last year, I only had a job making like 23 hours a week and also only getting paid $10 an hour.
So what did that have to do with you not reporting? Nothing. Not to bore you, but I went through school, worked 3 jobs and went through school, law school. 3 jobs. And if I can do it, anybody can do it. I mean, I'm not Superman. So I'm whining about I can't get a job, doesn't work, or I can't get enough. That goes just like that. It means you're too lazy or you don't give a flip. That's what it means, because they got jobs every place. I think 8 years is right on this. Anything else to add? On anybody's
kind of request. Reiterate my question on that, to take his plea, wait for 3 months, see how he's doing, and then make a decision at that point. Let's give him a chance to make some payments and to do what's right for these victims. I think that's the.
All right.
And then if he doesn't, then 8 years is gonna happen, and he knows that too now.
All right, I'm going to make the following findings: that there is sufficient evidence supporting these motions to revoke probation in each case, as allegations 1, 2, and 3 have been proven true, as the defendant has voluntarily, knowingly, and intelligently admitted his literal absolute failure to follow in his requirements in these probation cases that we leniently dealt with him on and gave him a second chance to atone. Each of those result in a sentence, a potential sentence in each case with a revocation based upon failure to follow the terms and conditions of probation, as in this case, result in up to 2 years in the state jail. And up to 2 years in the state jail on each case to run consecutive to each other is what is just and fair in each of these cases. Do you understand, Mr. Millard? I'm going to continue. I'm going to give you one last chance. And I'm going to review this every 4 weeks. And if you fail to impress me significantly each time, we're going to pick up just where we left off, and it's 2 year, your probations are revoked, 2 years confinement in state jail, and those will run on top of each other. So that's 8 years. And you know what the parole is, or they're nothing. It's nothing for a state jail. So I'll see it every 4 weeks, and please report from probation any failure. 100% failure is not an option. It's an option, but it's a tragic option for you. Okay. That is all.